Hello and welcome to Anulysis Law, and in this video we are going to see the exclusive jurisdiction which is conferred upon family courts and not to any civil court of ordinary jurisdiction or any criminal court. For the purposes of conferring jurisdiction upon the family courts are given the status of a district court. That means all the powers which may be exercised by a district court can also be exercised by a family court equivalently. So, family courts were established under the special regime of the Family Courts Act 1984, and therefore Section 7 and 8 of the Family Courts exclusively deals with the jurisdiction issues relating to family courts. So, Section 7 specifically, in fact, Section 7(1) explanation provides for certain category of family disputes which have to be exclusively be dealt by the family courts itself. So, let's see what are those kind of matters or what are the nature of such disputes which can be dealt by the family courts. So, the first category of such disputes are related to the declaration, or in fact where the suits or proceedings are between the parties to the marriage and where they seek for the declaration of their marriage to be null and void, or for the annulment of their marriage, or for the restitution of conjugal rights, or for judicial separation, or for dissolution of marriage or divorce. So this is the first category of cases which are provided under Section 7(1) explanation, that such kind of family disputes have to be dealt only by the family courts and not by the civil courts. So, where the parties have to get their marriages declared to be null and void, or to dissolve their marriage, or where they want to live together, in either of these cases they have to go before the family courts. The second kind of disputes here are covered as the declaration as to the validity of marriage or as to matrimonial status of any person. What does this mean? This means that suppose there are parties to the marriage, they have undergone matrimonial ceremonies, or they have married to each other, but their family or might be the society is not aware of it. So, in order to get the matrimonial status declared to the society and to validate their marriage, they may seek the doors of the family courts. And it is not just important that this has to be done only during the subsistence of marriage. Even if either of the spouse has expired, even in such a case, the spouse who has survived can also seek the family courts in order to get its matrimonial status declared by the family court. Another category of family disputes is related to the property of parties to the marriage. So here the parties can be either both of the parties, that means parties to the marriage means there has to be husband and wife, or husband or wife. It is not in respect of intersay brothers, sisters, mother, father, etc. So it is only between the parties to the marriage. So where either the couple is holding the property jointly, or either of the spouse they are owning that property, or they are possessing that property. So if such a matter is related to the property which is arising between the husband and wife, in such a case that matter can also be dealt by the family courts. Another category is given under explanation D to the to Section 7(1) of the Family Courts Act, and it is again related to the order or injunction which are in circumstances arising out of marital relationship. So where the parties are seeking for any order or injunction where the circumstances are such they have arisen out of a marital relationship. This is making it clarify that it is not just important that only the matter has to be between husband and wife. The matter can also be between a daughter-in-law and her parents-in-law, because in such a case this matter is arising out of the circumstances actually which are a result of a matrimonial relationship or a marital relationship. For example, let's see a daughter-in-law who had been harassing her parents-in-law for a long time by making false criminal charges, false allegations against her parents-in-law, and she's continuously trespassing their house. So in such a case, the parents-in-law can go before the family court to get an injunction order against such a daughter-in-law. So you cannot say that because now here parents-in-law and daughter-in-law, they're not interconnected to each other as a husband and wife. But the thing is that this relationship is arising out of the circumstances are such that they are arising out of a marital relationship, and therefore such matters can be exercised by a family court. Now the other category is related to declaration as to the legitimacy of any person. Legitimacy of any person means if there is a offspring of a man and a woman, and that child, that offspring, that child is not obviously not minor. I'm not talking about specifically a minor. I'm talking about generally an offspring of a man and a woman, and that person wants to get his legitimacy declared, that he is a legitimate child of that man and woman. But for that thing, there is a one condition. He has to establish that the man and the woman of whom he is claiming himself to be the legitimate child, he must establish before the family court that they are legally wedded parents. That means it is not that they are living in a live-in relationship. They must have undergone some matrimonial ceremonies. They must have been married to each other. So if that child's or if that the person who is actually claiming for the declaration of his legitimacy, if his parents are not having a matrimonial status, if they are not married to each other, but they're just living as a live-in relationship or any other relationship, in such a case, obviously the family courts would not be having any jurisdiction to exercise such matters. Now the next category is related to maintenance, including that provided in chapter 9 of the CRPC, and also apart from what is given under chapter 9 of CRPC, all the personal laws. So in personal law, for example, Hindu Marriage Act, Special Marriage Act, Hindu Adoption and Maintenance Act. So all these acts are also providing for maintenance provisions and alimonies. So all those provisions would also be falling under the ambit of section 7(1) explanation of the Family Courts Act 1984. Now the last category of matters is related to the guardianship of the person or the custody or access to the child, to the minor child. So the matters which are dealing with the guardianship of a person, mind it is related to guardianship of person. It is not guardianship of the property. So any person who has to be appointed as a guardian of a child, of a minor child, in such a case, it is the family courts who is going to decide that whether that child or who shall be the guardian of that child, or if that matter is related to the custody or access to the child. In such cases, it is only the family courts and not the civil courts which are going to exercise their jurisdiction. I hope through this small video you could understand the jurisdiction of family courts. Thank you so much for watching this video.